I welcome you all to the second session for today. We have with us CA NC Hegde, who's a past CCM, and he will be guiding us on all the various aspects of NRI taxation. To formally introduce the speaker for today, he's CA NC Hegde. He's a partner with Deloitte, and he practices in the areas of tax and exchange control regulation. And he was the Central Council member of the ICAI between 2016 and 22. I think most of us are already aware about who he is and does not require a very detailed introduction. I request you all to carry on a round of applause for welcoming. I would like to invite CA Jayesh Shari and CA Bhavesh Shari to present a memento and a towel bouquet on our behalf. I'll just start your presentation. Yeah. The presentation में चालू होगी सर.
ऑनलाइन भी होगी. Good morning, colleagues. Good morning. Really good and happy to see all of you after a while. A lot of you did comment, and actually I'm grateful. They said that they came to see me. I've not seen or heard of me from a long time, so I really appreciate it. आजकल family members को भी एक दूसरे के लिए वक्त नहीं रहता है. So I appreciate that gesture. For those of you who don't know why I was missing for the last 4 years, there were some health challenges. My family, my wife had kidney failure, and she was on dialysis around the time of COVID for a week. For a year, and then she had a transplant, and I was a kidney donor, which I very proudly delivered. And therefore, during that period and after that, I didn't contest the elections also because, as you know, in case of kidney, the very important thing in the first 2-3 years is that there should not be an infection, because the kidney recipient has to be on immunosuppressant drugs throughout his lifetime, or her lifetime in this case. Also, I found it a little, a little unflattering that when you see the total number of kidney donations, most are by women to men. And therefore, I would encourage people in the audience that please, you also must encourage to also donate to women as well. Most of the time, it is a mother giving it to a son or a daughter, or to her daughter, to her husband, to her, and things like that. But maybe less than 5% giving a man giving it to a woman. And I think that miscarriage. More than that, anything else, I think I take this opportunity to also canvas that, we must pledge our organs after death. I think that is one of the most best things to do, because with that you can at least help 6 or 8 lives. Because if a man is brain dead, then he can donate his kidneys, he can donate his liver, eyes, etc. So you can be of great use after your death. And if that happens, then living people will not have to donate anymore, because the cadaver donations will take care of the number of people. And India is a diabetes capital. A lot of people facing kidney challenges, and therefore I think it's extremely important to also do our bit for our people, for the loved ones as such. Okay, with that I move on to the topic of non-resident taxation. First, pardon me, you may find me a little rusted because of late in the last, as I said again, for a host of reasons. Again, I moved my role to being a tax expert to also being a talent and an HR expert, I was looking at the entire talent portfolio for Deloitte India. And therefore, that of course meant looking after matters of about 25,000 people now in India we are. And that gave me less time in tax, and therefore maybe you may not find me as sharp. But of course, the whole point is now I'm back into action and more than happy to help. If you have a query, please let me know and I will try and resolve it at the earliest possible. I'll leave my email ID with convener and then you can reach out to me whenever required. So what I propose to do, there's a fairly long presentation. I think it must have been emailed to you. It's about 58 pages. The idea is not to go through all that and make it complex. Idea is to try and highlight some of the important points in relation which you must look at in your day-to-day matters as far as your clients are concerned. Right? With that, I can start. So the first and the most important thing of practical importance to you is the fact that why are we looking at non-resident taxation? The reason why we need to look at non-resident taxation is because of section 195. Otherwise, most of us would not be too concerned because it would have dealt with non-resident clients per se. And therefore, at times, you may have some you approach you, some don't approach you. But the point is, under 195 of the Act, there is the obligation, which is the part of the TDS, which is a vicarious liability. As you know, we discharge the liability on behalf of the government, and the payer has to deduct tax at the rates in force whenever he is making payment to a non-resident. The idea is very clear. The department says that I'm not going to change the non-resident because a non-resident is elusive. Very often they used to send out earlier messages or notices to embassies. A non-resident would tear it, put in the dustbin. There was no way of enforcing the law against a non-resident very easily. And therefore they thought the best thing to do is to try and put that entire obligation on the resident so that the resident is made liable for deducting tax on the income of the non-resident. And as you would note, unlike many other provisions of the TDS, where there is a 2%, 10%, 5%, as the case may be, in the case of 195, you have to deduct tax on the overall liability of the non-resident. So whatever the total liability of the non-resident, the tax which has to be deducted, that amount has to be deducted and deposited with the government. So it becomes very critical to then understand what the liability of the non-resident is. And as a result, one has to therefore understand the provisions of non-resident taxation and what are the areas in probably which when you're making these payments to a non-resident that you need to withhold tax on or could be subject to a withholding tax because a client will come and ask you to issue you a certificate in 15 CB, and that is where this becomes very important. Time of deduction, credit or payment, whichever is earlier, as you know, not very different, right? It provides for deductions of rate in force. Now, whilst I have in the presentation covered largely the principles as are laid out in the Income Tax Act, domestic law, one very important thing that you need to remember is that when you are dealing with non-resident taxation, you have to look at both the domestic law and the tax treaty and whichever is more beneficial. And that is because of section 90 subsection 2, which says that when there is this thing of a non-resident, then you are entitled to take the benefit of the domestic law or the tax treaty, whichever is more beneficial. So you find the tax law more beneficial. If the Income Tax Act says no tax data required or not taxable in India, follow the domestic law. If you find the tax treaty is more beneficial, for example, now the domestic law talks about 20% of TDS on payments for royalties and fees for technical services, and you find that in the treaty there's only a 10% rate, then you go to the treaty and take benefit of the treaty. So that is why it's very important both to know the provisions of the domestic law and the treaty, because both are equally important as such. And that is also what is built into 195. In 195, they say that you deduct TDS, but while deducting TDS, you can consider also the provisions of the tax treaty, obviously, because when you compute the final tax liability of the non-resident, you are allowed to take the, as I said, toggle between the two. Toggle is a term that we use in in IT quite a lot, right? So both you can take the provisions of the treaty or the law, whichever is more beneficial, and that is something that you're required to do. Important case laws which are in the context of the tax treaty is that when you apply the tax treaty rates, then you don't have to apply surcharge and cess. And this is a question which comes up because there could be a 20% in the treaty, there could be a 20% in the domestic law. When it comes to a domestic law, you have to include surcharge and cess, which makes it effectively a much higher rate. Whereas when it comes to a treaty, if it is 10%, 15%, 20%, you only apply that rate and nothing more. For that, you have many authorities which I have put down on the presentation. This presentation will be made available to you, so don't bother to note them as such. Okay, so having explained to you on why it is important to understand what the implications of non-resident tax are, we now come into what is non-resident taxation and what is the whole basis of non-resident taxation. How does it arise? Why does it arise? Where does it arise? When does it arise? Right? So Section 5 provides scope of total income. It is on the basis of your resident. There are three categories, as you know: resident, not ordinary resident, and non-resident as such. Now, resident and resident, but not resident, as you know, is worldwide income is taxable. So if an Indian goes and earns income anywhere, all that is taxable in India, whether he is going abroad and earning taxation. For example, if an actor goes, earns money on all the film shows, when he comes back, those are clearly taxable as such. But on the other hand, when it comes to a non-resident or a not ordinary resident, then only his incomes which are either arising in India, received in income in India, or which are deemed to accrue or arise in India, which are so taxable as such. So this is an important concept. And it is very clear. This is again based on, as you know, all kinds of law are based on fundamental common sense. And you cannot have, say, for example, a Donald Trump who's sitting in the US, he cannot be liable for tax on Indian income being a non-resident unless there is some nexus, unless he has earned income from India, unless one of those Trump towers pays royalty to him as Donald Trump or whatever it is, then there is a nexus in relation to that income, and therefore he can be liable to tax in India. If he does a transaction in the USA, obviously India cannot have the right to tax, because there can be extraterritorial taxation, as the Supreme Court has held, but that extraterritorial taxation also applies within certain limits and wherever there is a clear nexus to any kind of an India-based situation as such. Right, so total income of a non-resident, what does it include? It includes income received or which is deemed to be received during the previous year, income which arises, accrues to arise, and deemed to accrue or arise as the case may be. So income received is if you are making any payment to a person, to a non-resident, then that amount becomes immediately taxable under Section 5 itself. Then you don't have to look at any other provisions of the law as such. And this is something I'll illustrate, which has caused a lot of difficulty for people who are on foreign going ships and Indian ships like Shipping Corporation and all of those who are going on sometimes for voyages, that they may have been non-resident. The number of stay in India, number of days would have been less than the whatever the threshold was. But because income was received by them, then that income became taxable in their hands as such on the grounds of receipt under Section 5. Now, Section 5 has to a great extent that rigor of Section 5, it said that the moment you receive it, you will get tax. It's been relieved by treaties. Because under the tax treaty, what is taxed of any foreign company or any person is only if you have a permanent establishment in India will you be taxed on incomes that you receive. Otherwise, incomes merely by receipt, you are not taxed as such. But you must remember that under the domestic law, receipt attracts taxation, which may be then relieved in terms of tax treaties that India has so entered into. Then you come to the next kind of cases, accrued in India. What does accrue in India mean? Say, suppose you have Nusrat Fateh Ali Khan or Rahat Fateh Ali Khan, whoever they were, they're coming, maybe they're living in UAE, they're coming into India, they're performing in a show somewhere. And when they perform a service in India and they earn money from it, then that income is considered as accruing in India. because it is their performance in India which has given rise to that particular income, and therefore that income is so accrued in India as such. So that is the category of accrual in India. So as you see, in the first one, there is a receipt. In the second one is the actual performance of anything in India, as a result of which it is accrued. And the third category, and the most important category which is used, is the deemed to accrue or arise in India. Now, deemed to accrue or arise in India has been defined or extended in terms of Section 9 of the Income Tax Act. And therefore, we have to examine, if you want to look at the Income Tax Act, Section 9 is like the Bible, right? From Section 916 to 911 to 917, it lays down various categories by which a person's income, a non-resident's income, is deemed to accrue or arise in India. And that is how a non-resident is so taxable in India. But do remember, a lot of people do get confused. If something is taxable under Section 5, if you come and rendered services or you received incomes without the benefit of a treaty, you get taxed under Section 5 itself. There's no need to go then to the deeming fiction, which is so provided under the Income Tax Act, which is deemed to accrue or arise in India. Right? So this is just a chart which explains which are the kinds of income. This only reiterates what I just mentioned. Maybe we can keep it towards the end, all the questions here. So first, Section 911. And now what 911, as I said, there are provisions Section 911 to 917. What does 911 say? 911 says is a definition which has been there right from the whatever the 23 Act and whatever it is, the 61 Act, which says that all income which arises, accruing or arising directly or indirectly through a mini business connection in India or through a property, 4 limbs: business connection in India, property in India, through an asset or source in India, or through a transfer of a capital asset situated in India. In these 4 categories, income will be considered to have deemed to accrue and arise and through a particular business connection or the other 3 limbs. Let's take the last limb, because that is the one which became very popular, which is the transfer of a capital asset situated in India. Which means, let's take, for example, Mr. Ellen Mittal, non-resident. And let's take, for example, Mr. Vijay Mallya, non-resident. Mr. Vijay Mallya says, I got shares in United Brewery, etc., etc. I am going to transfer all those shares to you, Mr. Ellen Mittal. Please purchase the shares. And he says, okay. Now, both of them are non-residents. And both of them are not liable unless income is deemed to accrue or arise in India. But because the shares of a UB company are situated where the share capital, where share register is located, therefore that capital asset is supposed to be situated in India, and therefore it becomes taxable under 911. So if a non-resident transfers to a non-resident, but shares of an Indian company, capital asset situated in India, becomes taxable in India, no question at all. It was always so taxable. But in the case of Vodafone, what was examined was non-resident to non-resident, but shares of a foreign company that were so situated in India, and therefore the Supreme Court held that this doesn't accrue or deem to accrue or arise under Section 911 because the shares were located maybe in the Cayman Islands or whatever it is. The seller was Hutchinson Max, which was again maybe based in Hong Kong. Purchaser was a Vodafone, which was based in Netherlands, but not taxable in India because not situated in India. So like that, if there is from an asset, a lease of an asset, or through a property or a business connection, in all these 4 cases, income will be considered as having deemed to accrue or arise in India. So on business connection, there is the taxpayer has to have a business connection. Basically, business connection means there has to be a little bit of regularity of transactions between the non-resident and the resident. And based on that, it is what the Supreme Court has held in the case of Hegde Agarwala, that a business connection will arise. The second last bullet, the expression business connection postulates a real and intimate relation between the trading activity carried out outside India and the trading activity which is carried out in India. So having seen what a business connection is, right? Now, within the business connection, we saw that if there is a trading activity, then that becomes taxable in India. But there are certain exceptions in relation to this business connection. There is something called a significant economic presence, which we will come to now in the subsequent slides. But the important point to note is that only that part of the income, even if you have a business connection and income is deemed to accrue or arise in India, doesn't make the entire income of the non-resident taxable in India. It is only that portion which is attributable to operations carried out in India which is so taxable. And let us again understand this. Let us say that there is so much of infrastructure activity going on. And say, suppose some of these coaches which were built in China, metro coaches, or let's say some other equipment, turnkey projects, power projects, lot of equipment which is sold in India. Say, let us suppose that the Indian purchaser insisted, that the Indian government authority insisted that I'm not going to take the delivery of the goods there outside India. You will have to come to India, demonstrate the goods are working. You will have to do a turnkey project. Only when I see the successful commissioning of the project will I consider this contract to have been completed. That means some part of it is completed in India, and therefore there will be a business connection, will be taxable in India. But remember that income arises because of several limbs. First of all, there is that manufacture production, right from research development to training, testing, etc. Then the sales element, and finally the selling to the customer as such. So out of 100 rupees, take for example, there could be at most what people had said was that only 25% could be probably attributed in India because of the selling activity, because balance what you did, all the manufacturing, research, etc., outside India, that is not really accruing or arising in India, even if there is a business connection in India. So that's important to remember that you can't, even if there is a business connection, you can't tax the entire 100 rupees. You can tax only whatever is the amount limited to India. In case of power projects and turnkey projects, there is a circular which says maybe 10%, 15%, like you have in the presumptive taxing. Then only 10% or 15% of the receipts will be considered as being accruing or taxable in India as such. So that is the important. Then there are two exceptions in business connection, which have largely been governed because of factual situations. One, because of news agency, because when BBC wanted to set up in India, wanted to collect news and send it out, then at that point of time, the question was whether BBC will be exempted. They were given an exemption to the extent, and the same thing can be applied maybe to an Al Jazeera channel or whatever channel which is actually sending news, only collecting news and sending news outside India. For them, business connection will not happen, even if they have a regular activity between the foreign company and the Indian company. The other exemption was again brought into the act because of the shooting of the film Gandhi by Richard Attenborough. And at that point of time, they said, because you are shooting a cinematographic film in India, there's a lot of accruing in India. Still, it will not be taxable in India, not be considered through a business connection, because they wanted to specifically exempt films. So today, if a client of yours is going and shooting in Ramoji Rao city, in Andhra Pradesh, because there they really make films very fast. 45 days mein film khatam ho jata hai. And he wants to do that, then that element of that film and the income which would have arisen because of the shooting and everything happening in India will be exempt because of the question of business connection as such. Similarly, where in order to encourage exports, business operations which are confined to goods which are exported to outside India, that also is not considered as a part of a business connection in India. So these are all the exceptions to a business connection rule which I mentioned earlier under 911, which says real and intimate relation between the activity as such. Then under business connection, there are certain activities. The business connection was a definition which held the field for many, many years. But then what started happening was that there are, after liberalization, after 91, there were many people who were actually acting as an agent in India on behalf of the foreign principal, so that the foreign principal did not really have to be present at all. And the agent was doing everything, including virtually signing the order for the non-resident as such. And in such cases, therefore, business connection definition has been extended to mean that if you, unless you are an independent agent, But if you're an independent agent performing all those activities, then you will be considered as having a business connection under Section 911. The treaty also has a concept of a permanent establishment happening because of being an agent of a dependent status. As such, same thing was sought to be brought into the income tax. Otherwise, as I told you earlier, otherwise somebody would have argued that, okay, I'm treaty exempt, I'm taxable under the treaty, but I'm using the benefit of the domestic law, and therefore under domestic law, I'll not be taxable on the agent's activity as such. So therefore, they had to make this amendment in the treaty as such. This is an interesting case of a business connection and how far the tribunal has extended the logic of business connection. I'm not sure whether this is a decision which correctly represents the law, but it is an important decision given by the Mumbai tribunal, where Volkswagen Finance here was a company, and that and Audi India, they wanted to plan a big event in Dubai because they wanted to launch the Audi 8, the latest model as such. So what they did is they took about 150 top-end customers to Dubai, and they brought a Hollywood actor called Nicolas Cage. I don't know whether you've seen Face Off. Face Off is a movie where they change the face and things like that with John Travolta and others. So Nicolas Cage is a very famous Bollywood actor.
Face off, face off.
Yeah, Face Off. That's what I said. Face Off. So with that, I think they copied that in one Hindi movie also. I forget what that Hindi movie immediately was, but where the new face has been given to the individual because one is a bad man, one is a good man, things like that. So Nicolas Cage was invited to Dubai, and in Dubai he performed whatever event and things like that. And then the question was that when this Volkswagen Finance has made payment to Nicolas Page for performing in Dubai, very clearly it is not accruing in India. It's not also deemed to accrue and arise in India unless it will have an element of technical services or royalty, as we will see. Then how would this be taxable? The department taxed it on the basis of business connection by saying that virtually everything was done for the purpose of the India market. The entire ad was for the India market. You took 150 people from India for the purposes of the Dubai event, and Nicolas Cage actually performed for all those people, and therefore this should be considered as a business connection as such. The tribunal there said that, yeah, now your old concepts of business connection in the old brick and mortar business where you had to actually sell goods, etc., they have all gone. Now this is the age of the internet economy and the new line online commerce and things like that. And therefore, even if you had a target audience there in Dubai, then there is a business connection which is involved, and therefore Volkswagen Finance was held to have required to be making withholding taxes on the payment as such. So this is a little extreme. I think the tribunal has gone a little extreme without having the law for that. But why I'm mentioning this case law is because you will immediately come to the next point, which is that the law was amended recently by the Finance Act 2020 to provide that all such kinds of electronic presence in India will also create a business connection in the form of significant economic presence. So as you can see, there are 3-4 things like an advertisement, data collected, sales of goods and services. All these will give rise to a significant economic presence, even though the non-resident has no physical presence in India. But because he is using online medium, e-commerce or whatever it is, if he has significant economic presence, which means that in terms of a revenue test, if the income is more than 2 crores from an Indian resident in relation to these transactions, then he will be considered to be having a business connection. And if you look at users, if there are more than 3 lakhs users using something, take for example, WhatsApp. WhatsApp's owner today is Facebook. There is so much activity happening on WhatsApp, and I'm sure WhatsApp, they are tracking on trailing because there can be no free lunch, right? And when they are doing all this, there may be millions of users in India on WhatsApp today, right? So that base, if Facebook doesn't have a presence in India, it would not be taxable because no physical presence, they can't tax under 911 or whatever else. And if they had generated some advertisement revenue, that would not be taxable in India. And therefore, this threshold of 3 lakhs users, which means that there is significant economic activity, that nexus which otherwise it would have failed on the provisions of constitutionality. There's no nexus. So in order to say there is some nexus, this provision has been brought in as such. So that is what you have to remember. But this, of course, will also be subject to the tax treaty provisions. Tax treaty provisions will continue to insist that if the non-resident has a permanent establishment in India, then only will he be so taxable. And therefore, you would have to examine both the significant economic presence and the tax treaty to see whether there is actually a presence in India or not. Right? So that was section 911. 912 deals with salaries. 4 deals with, I think, interest. Interest, if a person makes any payment for interest on a non-resident loan, etc., then that income is deemed to accrue or rise in India, and you have to deduct tax at source on the interest as such. Then 6 and 7 are very important for us because they deal with royalties and fees for technical services. And in 90% of the transactions that India must be having with a non-resident, it is either a case of payment made for a royalty or payment made for fees for technical services. And therefore, I've laid a lot of emphasis because when it comes to 195, very often you will have to look at, is this something which is taxable as royalty in the hands of the non-resident? Is it something which is taxable as fees for technical services in the hands of the non-resident? Then it is so taxable as such. Now, royalty is defined under section 916 under explanation 2, and it is a pretty long definition. Basically, it is use of all or any intellectual property rights. If I take, for example, a Holiday Inn, or you now have a Novotel here, if they are paying, you may have an Indian owner of the hotel. It may be a Suri, or it could be a Mehta, or whoever was the Indian owner, promoter of the company. But if he is paying for the brand name Novotel or Holiday Inn, he is paying for an IP, an intellectual property, the right to use the name Novotel or Holiday Inn, etc. In most cases of hotels, it is a payment based on the room revenue, 3% of room revenue, 2% of room revenue, whatever they have contracted on. And that when they make that payment is considered as royalty in the hands of the foreign company as such, and the Indian company will have to deduct tax at source. That is a very basic example of intellectual property rights, but all other things which are essentially patent, invention, model, design, secret formula, trademark or property, or technical, industrial, commercial knowledge, industrial, commercial equipment, copyright, artistic, all this will fall under royalty. So the moment you see anything which you feel is in the nature of an intellectual property right, please come and examine the definition of 916, and probably it will be so covered as such. Now, as I said, 911 was there for a very long time. And 911, what it provided is there has to be a business connection between the non-resident and the resident. Therefore, what most people would do is they would say that we don't want to come to India and do the business. We will give you an engineering, design and drawing outside India. We'll give you the technical services outside India. You send your people for training, and therefore the non-resident is not taxable in India. So what then India said that, no, what they brought in a rule in 76, which is called the source rule, which is still prevailing, 916 and 917, which meant this, that as far as an Indian business makes a payment to a non-resident for either technical services or for royalty, then that amount is deemed to accrue or arise in India, irrespective of what the non-resident is. So the non-resident doesn't have to come into India. Moment I pay for an engineering designs or drawings, or for a property right, as I said, or for any kind of training services, the moment I put it and debit it to a business, then that amount becomes taxable. Just like Volkswagen Finance, of course, it was probably not a royalty or fee for technical services. Otherwise, the moment you would have debited for the payment paid to, say, an engineer or any technical consultancy that he bought, that would be taxable in India. So that is the importance, that it has extended the limit of the tax from overseas to also transactions in India with a non-resident as such. And that's why this was often challenged on the grounds of extraterritorial operation. When it first came, it was criticized heavily because they said that Mr. Palki, an example in his book, and he said that if I go to a London barber shop and if suppose the fellow cuts it stylishly, nowadays you find most barber shops everywhere, majority are barber shops, whether a Javed Habib or whatever, Be Bloom or whatever it is. Suppose he was to go to a shop there, and suppose if that was to be considered as technical services by the tax department, then I would also to deduct TDS of the London barber's income. So he said that look how ridiculous this can be taken to, that I have to deduct tax at source even on a non-resident income just because it becomes and it is paid by a resident here and which is applied maybe for the purpose of his business or whatever it is in India, not for the purpose of personal services, but for the purpose of a business in India as such. So that is how it is deemed to accrue in India. The reason for explaining all this is there is one important exception which sometimes is not available even in the treaty. And that exception is both here and in fees for technical services is that when you use that intellectual property right or the technical services for a business that you have set up outside India, take for example, here Sun Pharma. Sun Pharma has taken the help of a lawyer or whatever, but not for the purpose of India, but for the purposes of setting up an operation in Israel. They have a relationship with the Israel company called Tavo, which they acquired, merged, etc. So that for that Tavo, suppose if they had used some services outside India, then that otherwise would have been taxable under 916 or 917 because it was paid by business in India. But because it is used outside India, it is not so taxable because it is utilized outside India, a little bit like the service tax and the GST concept, where it is the utilization takes place. So like that, that same utilization is happening outside India, though paid by an Indian resident, by a Sun Pharma or a Graphite India or whoever it is, therefore not taxable in India.
Sir, in that form 15CB, you have mentioned those specific things that can
Yeah.
be utilized.
Absolutely. And you will have to make a mention of what exactly is the utilization. Even if you may pay a lawyer or a technical services or etc., whatever it is, there are some case laws which have held that even for all your 100% export oriented SEZ companies, if you have made any payment to a foreign company, but because your entire 100% income is for earning business income outside India, therefore it should not be taxable. It's a little debatable, but that's the concept. Concept is if it is not for a business in India, if it is either for a branch or an office set up outside India, then clearly not taxable. But even if it is for an operation which you carry out in India, outside India, then it will not be taxable.
Sir, yeah, counter bank guarantee, whatever it is coming from foreign holding company. So what would be?
Counter bank guarantee will go more under the interest, and you will have to examine it under the tax treaty, not under fees for technical services or royalty.
Suppose that in domestic, in India, domestic company is giving guarantee, but the limit is with the foreign company.
No, so as I said that in the treaty, there are some treaties which treat it as interest, some which don't treat it as interest. So if it's not considered as interest with that treaty or that country, then it will not be taxable. If it is considered as interest, then it will be taxable. Under section 915, which is the interest clause, it will be considered as taxable in India. So you will have
Bank guarantee charges. They say that bank.
yeah, bank guarantee charges or anything, guarantee commission, whatever. It is all forming as a part of interest as defined. Because if you see interest, you have to go back to section 228A. I don't want to bore the audience with technical definitions. 228A has a very, very wide definition. And therefore, it includes that as well. Then what you have is in 916, you have certain explanations which were brought in because what was happening was computer software when imported by residents or used by India, then that was not being taxed. And therefore, royalty definition was amended, I think, by 2002 with, again, retrospective effect from 1976. One was computer software and two others were really aimed at covering satellite payments. And the second one was also trying to cover payments for industrial equipment of a particular type. Now, 6 was to deal largely with satellite payments. Because what is happening is with all the satellite TV and everything kept coming in, you have to, the person who wants to say a ZTV or a Sony wants to beam it to the television channels has to hire a transponder for a satellite. And that is a part of what could be considered as royalty, not royalty. The High Court held it is not royalty, and therefore they tried and amended the law. So that is the basic explanation 6. Explanation 4 was to try and bring in all kinds of right of use of software to tax in India. In terms of royalty, there's one very important point which has been a controversy for a very long time, and that was use of software. What happens to any software that your client imports? Now, will this be considered as royalty? It is normally considered for the use of a literary right, and therefore is covered under the Copyright Act, and therefore would be taxable. But when you buy your Windows license or any other kind of software, you don't really get a right to reproduce that software, right? You only get a right to use that particular software. And that is what the department argued. Sorry, the taxpayer argued. The department did not accept the plea. They said, no, all this is now we have also retrospectively amended the law by saying even a right to use the software will be considered as a royalty under the act, and therefore it is so taxable. The important distinction that was sought to be made was that let's take a book. Let's take a book, and suppose you have a foreign book. You have a lot of foreign publisher called Butterworths in a lot of books. Suppose you import that particular book. When I go to the bookshop and make a payment of say 1,000 rupees for the book, I'm not really getting the right of the copyright of the book. I cannot reproduce that book anywhere else. If I reproduce and I do like how we do the photocopy, etc., I may be liable under the Copyright Act. That there's an infringement. So when I make a payment for the 1,000 rupees for the book, I'm not really paying for the copyright as such, because the copyright must have been, if suppose an Indian publisher is given the right to reproduce, he will pay the Butterworths the right. Say, take for example, taxman takes the right for reproducing that book, then he pays for the copyright, and that could be considered as royalty for payment of a copyright, but not the ordinary user of a book who is really paying for the purchase of the book itself, which is a goods, and which is not the software really as such, or the copyright as such. So the same argument was made, and this is the important point you have to remember, is that the Supreme Court in a very detailed ruling in the case of engineering analysis held that this is not software. What you are purchasing is actually, sorry, it's not royalty. It is software, and what you're purchasing is really purchase of goods. And therefore, there is no royalty which has to be deducted when you make payments for all this kind of shrink wrap software, as it's called, where you only get the user license agreement to use the software and you don't have any right to reproduce the software. So this is a very important ruling of the Supreme Court. You can have a look at the ruling, very detailed ruling given by Justice Rohinton Nariman, who was one of the most learned judges in the Supreme Court at that point of time, where he has examined the entire Copyright Act and said that what that section in the Copyright right gives you a right to reproduce doesn't give you a right to, it only gives you a license, etc. And finally held that it is not so taxable in India. Then we come to some very common kind of issues that one notices from time to time. What happens in the case of subscription fees for access to online databases and journals? Things like a Dun & Bradstreet or a Bloomberg or whatever else it is. Now, even in this, in many cases, it has been held that if it is generic database which has been given and you have culled that out and you have given it to the Indian resident, then it will not be considered as a royalty, but it will be only considered as business income. As such, I have cited all these rulings here, Dun Bradstreet, American Chemical Society, etc., etc. And they have said that that is not really royalty. It is not commercial knowledge or skill. This was already available on the internet. They have actually only tried and edited parts of it, and then they are presenting it to you. Mind you, there could be a case where somebody has given you specific knowledge which is customized to your particular need. In that case, it would be held as being royalty as such, and that is something that will have to be examined with reference to the particular treaty. Then even on cloud-based charges, same point. Is there any use or right to use any kind of infrastructure software? And in most of these rulings, it has been held that no, there is no right to use. It is only a cloud. It is only a storage space which is so given to you. And therefore, it is not taxable as royalty per se. one important point I must mention that we will come to equalization levy towards the very end, right? Even after the software is no longer considered as royalty, now there is also a levy called the equalization levy. And though you will not be taxable under the head royalty, you could be taxed, the non-resident could be taxed as equalization levy, and also that is something that you will have to keep note of. So after the Supreme Court, no longer royalty, no 10% required, but there is an equalization levy of 2% which could apply, or it could also be taxed under the significant economic presence, as I mentioned. And that is where you will have to still examine the cloud charges as well as web hosting and software to see whether this is taxable under EL or not. Then there are many cases in relation to royalty. What happens when an entire package is given to you in terms of a plant? That means the entire operation of a plant, an entire package is given to you, but that package is given to you lock, stock, and barrel. It is not a limited right for you to use that particular know-how for the use of the machinery or building the machinery. The entire package is given to you. It is a sale of know-how as such. And in that case, it has been held that it is not royalty, but it could be processed under the head capital gains if made outside India and not taxable as such. Then many other cases of different situations, a right to use a trademark, whether that comes within the royalty or not, broadcasting rights, whether for video and live events. Under live events, there is a concept that a live event, there is no royalty as such. Only when it is recorded and then exhibited, then will it be a royalty as such. So you can have a look at it. I have put this all in the slide for the benefit of not making it too complicated and time. I'm trying to give you a overall overview as such. And the second very important provision under 917, which is fee for technical services. As I said, royalty and fee for technical services, these are the two things which come in practical day-to-day use when you are giving your certificate under 15 CB. And what is FTS? FTS is a managerial technical consultancy services or provision of services, other personnel. The same logic applies as I explained in the case of royalty, that you have to see if it is used for the purpose of a business outside India or for earning income outside India, then it will not be considered as deeming to accrue or rise in India. Otherwise, in all cases, if it is used for an Indian business, irrespective of whether it is performed outside India, got outside India, no problem. It will be considered as being deemed to accrue or arise in India. Technical services has been extensively defined. One of the latest definitions of the Supreme Court was in the case of Kotak Securities, where the bold charges for the stock exchange. Question was under the domestic law whether 194J will apply or not. And it is in that context that they said that if I am providing you a standard facility, that facility may contain some kind of technical expertise or equipment. But by making that payment, I am not availing of a technical service, which is a more a person-to-person involvement is really required. And therefore, it will not be considered as technical services. That is what the Kotak Securities ruling held in the context of 194J. The same can be also used because the definition for fee for technical services, as you know, is the same. Under 194J, they have taken the definition of 917 as such. So these are various definitions. This is what I explained to you earlier. Normally, it will be deemed to accrue or arise in India unless it is used for the purpose of business or profession outside India or for a source of income outside India as such. We then come to a very important concept in the treaty, which has helped people to avoid taxation on fee for technical services. And this is called the truncated or restricted definition as contained in many tax treaties, especially US, UK, Singapore, most of our important tax treaties. What they there say is that the fact that somebody has provided me a service, right? It could be a technology service, technical service, whatever it is. But unless I, on my own, without recourse to the service provider, am enabled to provide it, it will not be considered as fee for technical service. In other words, there has to be a transmission of the knowledge. Take, for example, I am teaching you something, If now tomorrow you are able to apply that same knowledge without my use, then I have provided you the technical service. But if you have to come back to me again for the provision of that particular service, then it will not be considered as fee for technical services. So in a lot of instances, for example, when you use a specialized service, and which was in this case, let me give the case of De Beers India Mineral. This is a case that I had occasion to advise, where our client was De Beers and was prospecting for minerals in the state of Karnataka. Now, for minerals, as you know, there's a very wide area and you don't know where to strike for the purposes of gold or diamonds as such. So what they did is they invited the services of a Dutch entity of a plane kind of a service which goes over the entire field and does a little bit of reading, like what exactly a drone does. Let's suppose I pay also for a drone, and the drone tells me that this is probably the best bet for you to try and get the benefit of your digging for the purposes of gold or for a mine or whatever, diamond, etc., as the case may be. So that entity was an entity called Fugro from Netherlands. And when we made the payment, the assessing officer said, this is nothing but a technical services. You have taken the plane and the people who are providing the service. And with that, you are benefiting, utilizing it in the Indian business. We said, yes, taxable maybe under 917, not taxable under the treaty with India and Netherlands, because whilst he's providing that service to me, as a result, I don't become an expert and I cannot do that same service if I have to do it over a mines in Chhattisgarh or wherever else, or Jharkhand, if I have to do a similar kind of prospecting. That means the important point is the person providing the service must enable me also to learn to do that service without recourse to that earlier person. So similarly, many other cases like this, and as a result of which it has been held that they are not taxable as per the treaty and therefore not taxable. Why this is important is that in many cases what happens is when you have contracts with non-residents, a non-resident normally says that I am not interested in India taxes at all. You will have to gross up the taxes. If you want to pay me, I want 100 rupees, $100. I'm not interested. If there's a 10%, 20%, I've heard Indian tax is very complicated. I'm not going to be there. You give me the 100, you deduct tax or whatever it is. And therefore, your client will add to the cost of that overall technology. And at 10, 15, 20% as the case may be, will make the entire thing very costly. So if you have the benefit of a particular exemption in the treaty, it helps you because in those cases of net of taxes contracts, it helps to make the entire technology, the cost of or the royalty or the IPR that much cheaper as such. Then this is the latest a ruling has come. I have not mentioned it for those of you who may want to note. There is a Supreme Court decision in Nestle which has come on the point. And the point was like this. It is a concept under the treaty. And as you know, we have entered into treaties with various countries. Now, there are two main blocks of countries that we enter treaty into. One is called the UN model, which is all the developing countries. And one is the OECD model, which is consisting of slightly advanced countries, US, UK, Netherlands, etc., etc. Normally, those treaty models are very similar, standard. It is like how the template that we take and we do a cut, copy, paste and see where to change, where not to change, etc. How we do, our juniors do appeals nowadays, cut, copy, paste, and then they change here, there, even if the old clients, one old client's name they put and they send it for appeal. So similarly, even in the model also, the OECD and the UN model, they are similarly drafted on the basis of a standard template given by the OECD and the UN. And what normally happens is if I enter into a treaty, say US was a treaty I entered first, and I entered into the Netherlands treaty later, right? So with US, if I have agreed with the government that I will provide it for a restricted tax or whatever it is, normally there is a clause which is also mentioning that if you enter into a treaty with any other member of the OECD and you give him more favorable terms, then you must also give me the same favorable terms in the future after the treaty is entered. So it is basically best like a best neighbors kind of a agreement when it comes to an agreement. So I say, okay, I have given you the right probably to use the lawn for a marriage function. And somebody in the building will say, okay, you gave A the right to use the lawn for the marriage function. I also have a marriage function. You must also give me that right. And therefore, B also wants that right. So that most favored nation clause means I will give you the right that if I reduce my rate in a treaty or I make the taxation much more restricted in the future, I will also give you that same right. And that is what is called the most favored nation clause. Now, the argument by the taxpayer was that when I enter into a treaty, normally the protocol contains a clause which says that if a subsequent, as I said, subsequent I enter into a treaty, then I will give the benefit of the treaty to the earlier person also, because at that point of time I had not agreed to the concession. In that case, is there a separate notification required by the government, or does the treaty automatically trigger the lower rate as such? And we all believe that it automatically triggers because the wording in the treaties were very clear. They said that if A enters into a treaty, then I will give B, whom with I have entered into a treaty earlier, the same rights as I gave A. Take an example. When Mauritius, we had no tax on capital gains for a very long time. Then Singapore came back and said, what you have given Mauritius, you must also give me. Because you are entering into a treaty with me, I want the same right. Because of that, all your people are coming via Mauritius to enter into India. So I want to make Singapore also an attractive destination. So you must give me the same rights. And that's why they gave Singapore also the similar rights. So this is an example of an MFN, as I'm trying to explain. But Supreme Court in the case of Nestle said, no, it is no automatic trigger. There has to be a specific notification which is issued by the government, and only after that notification will that right to you apply. This came only about 3-4 months ago. And this is a little bit of a, I would say, a difficult ruling because it makes us subject to the whims and fancies of the government. The moment everybody will have to go to the government and ask them to then issue a notification to notify the lower rate of tax. And only after that lower rate is so notified will the lower rate will be so available. Government has already issued a circular. CBT had made its point very clear that only if I issue you a notification will you get it. But one thought that the Supreme Court will not look at the CBT circular, but will look at the law as such and will give a favorable ruling, but which has not happened. Then there could be certain cases where the double tax treaty doesn't have a clause on fee for technical service at all. There's a clause for business profits, there's a clause for others, but there's no clause for FTS. What happens in such a case? And in that, there are many rulings which seem to say that in a case like that, then there is no taxation, it will be only taxes, business income. Kalpatru Power Transmission was a case of Kalpatru Power, which had an office in Ahmedabad. I think they had some business of power towers which they set up in the UAE, and they made a payment to a UAE resident. At that time, the treaty did not have a clause for fee for technical services. And therefore, they said there is no clause, and therefore, when I'm making a payment to a Dubai resident, then that will not be considered as fee for technical services. This is all that this says, and you have a lot of rulings as far as that particular point is concerned. This is the same point of what was considered. There could be various aspects where you make payment on the intranet, broadband services, etc. Department tries and argues that this is nothing but royalty because you are using standard equipment, technical equipment, which has got expertise. And based on the decision of the Supreme Court in Kotak Securities, we can very well argue that all these kind of payments will not be royalty. There's another thing which is very important, which comes practical use for a lot of you, is that what happens when you make payment to an agent for overseas commission? Is it taxable under the law? Is it taxable under the treaty? It is exempt or what? So first of all, one can argue that though there is a business connection, there is no income which is attributable to India because a non-resident agent is performing all his services outside India. So if you have a builder and the builder is having a non-resident agent who sells to all the UAE residents or the Saudi residents or the Malaysian residents some kind of a plot by saying new Cuff Parade or new this, new Hollywood or Kanakya Paris or whatever it is sitting in India, but that person, when you make a payment to him for the purpose of commission, it will not be taxable because one, that has not really accrued in India because of the business connection. 2, it is not fee for technical services, it is pure commission. And 3, in most tax treaties, this will not be considered as fee for technical services. Therefore, payment to a non-resident agent for overseas commission will not be taxable under the law. On leadership training fees, earlier there was a doubt because training does involve some amount of technical expertise and it is also transmitted. Unlike in other cases, I can't say that if I have trained a person, the person has not been enabled to know what he has been so trained, right? Otherwise, you will say that what was the use of that training otherwise? Give back the fees. So normally a training would mean a fee for technical services, but however, Pune decision recently has held that there's no technical services. They have put in a concept of make available under the normal law also, and to whatever extent you can use this particular ruling. Finally, we then come to reimbursement expenses. What happens in the case of reimbursement of expenses? Very often there is a charge which is made, and then there is also expenses which are sought to be reimbursed. Now, remember that when you are making a payment for fee for technical services, it is not really important whether non-resident has made a profit or not. Take for example, he incurred 100 rupees, but he's charging you 90. That means he's actually incurred a loss. But when you pay that 90, you have to deduct that income, or sorry, 100, you have to pay payment of the entire 100. He can't say that, no, this is not even covering my entire expenses and therefore this is entirely a reimbursement. Or he charges 110. In a case of 110, clearly there is a 10 rupees of element of profit. Or he says only 100. I am charging you exactly my cost of service. But in all these cases, it is not a reimbursement of, but your fees which is seeking to recover. But on the other hand, if he is saying that I have incurred certain costs like a transport cost while incurring the service, or I have paid a third party, a courier or whatever else it is, and I want you to reimburse that amount, then you can take a stand that is not fee for technical services and therefore not taxable as such. Important point which has now come up is in relation to the increasing tax rate. Now, as you know, that last year suddenly, not in the course of the finance bill, but while passing the finance bill, they increased the rate from 10% to 20%. And therefore doubled really effective rate of fees for technical services and royalties to 20%. Now, yes, in most tax treaties, rate is still 10%. But as you all know, there are huge problems of getting the tax residency certificate. And therefore, in many cases, people would go back at the time when 10% was the domestic law, 10% plus surcharge and cess, and try and rely on the domestic law to say that let me accept the domestic law because then I don't have to bother about whether there is a TRC or 10F or as the case may be. So this is now a problem. And why is it a problem? That now you will have to go back to the DTAA. And in the DTAA, you will have many non-residents who really don't want to apply for a PAN at times and don't want to give you a TRC at times. So in that case, you will have to go back to a 115A5 situation. But in a 115A5 situation, you will have a rate of 20% plus taxes. So where the non-resident is bearing the tax, it's not a problem. But as I explained, in a majority of the cases, the Indian resident is bearing the taxes, or the contract is called net of taxes, which means I have to bear the tax and give him the gross amount without deducting any tax at source. And that is where the problem will so arise. Also, there was an exemption under the law where you would file and the non-resident was not required to file a return under section 139 if he deducted tax at the rate which is provided under section 115A, which is now effectively 20% plus surcharge and cess. And what that means is that if he doesn't want to file a return, then the higher rate of tax will have to apply. If he applies a tax treaty, he will have to file a tax return and also be subjected to a higher, the TRC and all those other conditions. So because of this tax rate, now all these peculiar situations have come up, which is something that you must really look at. There's another concept just to make this complete, there is another concept in the case of double treaty taxation, which is there is now a concept called the multilateral treaty instrument, the MLI, multilateral instrument. And why did this come in? Now let's see, when India was having tax treaties with various countries, what would happen is that we would have to individually negotiate with all these countries, and they would negotiate. Take for example, Mauritius Treaty was entered in 1983. Where Mauritius was only an island, there was nothing else. It's like Lakshadweep now, there was nothing much there. Or say Maldives, there was nothing much there. But then Mauritius brought in an Offshore Act, Overseas Investors Act, and everybody started coming in via Mauritius. And the Indian government, there was an NRI Prime Minister called Anirudh Jagannath. They were friendly with the Indira Gandhi government at that point of time. We agreed to a capital gains exemption as such. And therefore, what started happening? Right from the 1990 when liberalization happened to the time, maybe 2015 or so, all the investments into India were routed via Mauritius because of the favorable tax treaty exemption that India-Mauritius had. India wanted to renegotiate the Mauritius treaty right from maybe 2000 onwards. So 10-15 years they were negotiating. But why would Mauritius renegotiate? Because otherwise it will be an end of his offshore business. And it's mainly relying on offshore business and on tourism to sustain the economy of Mauritius. So it will not really renegotiate. So this is what happens is when you try and renegotiate an individual treaty, it becomes very difficult. And therefore, at the OECD, they entered into a project where they said is that we will now enter into an instrument which is called the multi-level instrument, which means that India says that in royalty, I'm going to have the same position. At one stage, they can enter negotiations with all its treaty partners, which could be 140 plus as such. I don't have to go to one and one and negotiate with them. And that makes the treaty, whatever is the definition, etc., rates, etc., much easier for the Indian government to implement. Otherwise, Indian government is unfortunately only a bystander and cannot really effectively increase the taxes as such, which is required. So this is all about the MLI. India is in the position to keep on negotiating these MLIs where I don't have to go and negotiate the entire treaty. I can only put 3 or 4 clauses in the treaty. And the main one that they want to put is something like a GAR that the tax treaty cannot be used for the purposes of anti-avoidance, for purposes of anti-avoidance and such. And that is that particular treaty negotiation which is happening as a result of MLI. As you can see with USA, we have not yet signed the MLI because even there USA is saying, no, I will not agree. Because if you're having a lot of transactions and your residents are then pressurizing the government, don't renegotiate because otherwise India will want to tax everything under the sun. And that has been our attitude. And therefore, they will ask the US government not to negotiate with India. And that is what is the problem with the MLI as such. Then coming to the last concept, which is, as I said, equalization. Now, as I explained earlier, business connection would tax only a brick and mortar business where I had an actual and intimate relation between you and them. Now, they brought in the concept of a significant economic presence, have taken online transactions also on board. But in most cases, what was happening earlier was that you would advertise on the Facebook or on Google, they would give you all those adverts, etc., etc. They had not set up subsidiary in India. A florist, an Indian florist called Right Florist would advertise for flowers on sale on Google or whatever it is. But say that I don't have a permanent establishment in India. This is not royalties, it is purely advertisement, and therefore I'm not taxable at all. And that is how they got away with taxation in India for a long time. And that's why the Indian government, based on a global move, this was not only Indian government. The same thing happened with Google when it concerned in other countries, whether it was US, UK, etc. They saw that in Ireland it was paying only say 5% tax and not paying taxes in all other countries. And therefore all of them started introducing what was called as digital transaction tax. So the OECD gave them 2-3 measures. One, that you can have a test of significant economic presence and tax. Two, you could levy a flat digital transaction tax. Or three, that you could have a VAT, which is your GST for electronic commerce. Whenever you import and there is online retrieval of data, etc., then you get tax. India was very smart. It took all the three and applied all the three. So it has got significant economic presence, it has got VAT, and it has also got equalization levy. So the first equalization levy which came in applied to online advertisements. And if there was online advertisements which were where I gave you the example of a florist exhibiting on Google, and you used the online advertisements, then the Indian resident would have to withhold tax at 6%, which was called the equalization levy as such. And there was the person who was deducting like that had to. The problem with the equalization levy is that it is over and above the Income Tax Act. And therefore, one would not get credit for any taxes. So the non-resident will not get credit for taxes in his own country because it is not income tax. It is a separate levy called the equalization levy. From April 2020, this was extended to any kind of amount of consideration received online by an e-commerce operator for goods sold or services. So if you are operating, if Google is operating and Amazon is operating from outside India, and through that platform it is supplying goods and the sales are more than 2 crores, 2 crores they will do in one day itself, right? If they have an Independence or Republic Day sale or whatever, they themselves claim that you have done so many thousands of crores of sales. So like that, then it will be subjected to equalization levy. And now Google or Amazon or whoever it is will have the liability to pay tax at 2% of the gross amount of consideration. Luckily, the Indian person doesn't have to withhold tax as in the case of equalization levy 1.0. It is 2% which has to be paid by the non-resident e-commerce operator as such, which has brought an interesting twist. First, we said this is not royalty as you saw on the software. Now, a lot of companies are saying, no, this is something which is falling under equalization levy. Why? Because 2% of the gross and not 10% of the gross. And also there is a specific subsection in the Act, section in the Act 1050, which says that if something is royalty or technical services, then no EL will apply. So if it is also EL, then obviously it will not form part of a fee for technical services and royalty. Though the first department will always attempt first to tax it as fee for technical services or royalty because the rate now 10 and as per the treaty it may be 10, but as per the domestic law is 20%. And say that this is taxable under fees for technical services and royalty, not taxable as EL. But you have some cases where some of these like Coursera, which is the online courses which they offer when you can go and buy online courses and do courses as such. They also went to the courts. Now, as you know, there could be 195, you make a payment, or the non-resident could come and make an application under 197 and say that this is not liable to tax as royalties or fee for technical services. Give me the payment without deduction of tax at source. Therefore, under the 197, when it was in both these cases where it was whether rejected by the department, they went into a writ petition, and the Delhi High Court normally said that, okay, you may have an EL, so keep 2%, keep a little extra. It could also be taxable maybe under the old 6%. So keep that much, but you will not be liable to deduct at 10%. And to that extent, the non-resident will get relief. So it is very important. So now in cases, if there is an online seller, etc., then you will have to, as I said, examine that there's a significant economic presence, it is a royalty, or whether it is subjected to equalization levy. And that interplay of forces will happen as such. Thank you. With that, I know I was a little fast. I had to go. But I hope that it gives you a overall good kind of an idea of what the non-resident taxation was all about, because this is what it is. So that is very important. 911, but 916, 917 extends and makes it deemed to accrue or arise in India. And because of that, limit is increased. And therefore, whenever you make a deduction of tax at source, 916, 917 will come in the picture. Presentation, there are many case studies basically, which will tell you of how the courts have taken a view. Probably it will help you to help your client as such. I'm happy to take any questions. And then we can, yeah, please.
Who will pay equalization levy in this course area?
Coursera will play. As I said, in equalization levy 2.0, it is a non-resident who has to play.
May not have office in India.
But still, you'll have to make arrangements and then pay for it.
So in case of salary paid to a non-resident, the TDS will be paid in 192 or 195 because
If he is a resident in India, then 192.
a non-resident, the salary is paid to a non-resident. So company, I guess salary is
So
an
he
exception.
is outside India or what is?
No, the person is a non-resident.
Oh, he's a non-resident Indian.
Yeah.
So then he
Salary
will.
is paid, तो उसका जो TDS है कंपनी को 192 में ही जमा करना पड़ेगा.
192. Ideally, we do it under 192 only.
195 में.
NRI providing services, interior designing services to Indian entity through any desk and giving the plans through.
So that you will have to examine in respect to the treaty. And as I said, it may not be make available.
It is the NRI is in of UAE, where FTS is not there. I have read that.
No, that could be the old treaty as such. What you saw, Kalpatru power and all could be old treaty. Examine the treaty with UAE whether it contains. If it doesn't contain, then not taxable.
Then no need to deduct TDS as well.
No need. No need. That's the whole point. That your liability of deduction of TDS is co-terminus with the liability of the non-resident.
Even that income is not taxable to the NRI.
That you will have to examine that country. Either UAE there is a taxation or not.
While filing NRI returns in India.
Sorry.
While NRI is filing a return in India, that income will be taxable.
Once it is not taxable, it is not taxable in income only. No?
Sorry.
Yes. Yes.
If an individual loudly is paying the application fee to an international organization for registering the name. And if they're paying a certain fee, is that TDS deductible on that?
For registration for trademark for what purpose?
To use that name anywhere. It's basically an international.
That should not be normally taxable. There are a couple of cases which I have cited there, including there was a decision of the Delhi tribunal in case of GoDaddy. GoDaddy, which is a forum which provides for such registration, but afterwards there have been some decisions which have distinguished GoDaddy and said that it is not royalty.
Even if the receipt received from the organization says that it is for using that trademark, for use of trademark.
So, but basically they have held that this is only like a registration name for an IP address and things like that, and therefore does not really involve using a copyright per se.
Sir,
Department may contest it. As I said, in GoDaddy, the decision went against the taxpayer.
Sir, yes. Sir, for DTAA to happen, is TRC obtaining the TRC mandatory from documentation point of view?
Yes, it is mandatory.
Because practically it's very difficult to get TRC.
So TRC is mandatory. As per the law, you have to get a TRC.
Give the documentation. DTAA.
Yeah.
And regarding secondly, the explanation 7 to I think 911 quantifies the threshold limits. So for business connection to happen, is it to be applied straight to assessing any business connection or nexus while knowing you?
No, I think it is only for significant economic presence.
Okay, for SAP only is it that is?
Yeah.
So, it's a very SAP to open only you quantify that.
Yes.
So,
Yes.
property purchased in India by
Yes.
NRI in joint name with
This one.
residents Indian, 2%, jointly one residence, one NRI. If any rent received, whether we have to part with two or it can be taken in the name of a residence.
Means he is a non-resident Indian jointly.
He has purchased the property first name and his father is a residence. Whether this rent received to be divided between two or it can be taken by legal license agreement in the name of residence. Because there is some exemptions are there, 24, 2,40,000, so there will not be required to be TDS to be deducted. Is it okay?
So basically, you will have to compute the income of those joint owners because there's a concept of joint ownership, right, under section 26. Compute and see if there's a liability as such, and if there's a liability, then you'll have to direct tax source.
No, that rent received is an income.
Huh?
So how, whether it should be divided?
No, but
between two
the
or-
resident must be paying that fellow, na?
Yeah,
So the resident has to examine whether TDS has to be deducted or not.
no, residence, property purchaser is residence. And, means, person who is giving rent also residence, but NRI also a property owner. Co-owner.
Yeah, correct. So
So they
NRI is
will-
having joint property with a resident, you're saying, na?
No.
Resident and non-resident is a co-owner.
Correct, co-owner.
And the, rent is paid by the residents.
So that is why when a person pays a person and you have a person who is a non-resident as a co-owner, you will have to examine under 195. But before that, you will have to compute the income of that non-resident co-owner. And if there is tax deductible, you will have to deduct tax at
No,
source.
what I'm telling you, the, rent payer should deduct TDS for NRI as well as the residents or only, because living license agreement in the name of residents only.
No, that
Yeah.
just because it is the name of the resident, but it is taxable in the hands of a non-resident, you will have to deduct tax at source.
Source of investment, sir. He is trying to convey that.
Yeah, yeah.
Rent is own rent.
If entire rent, if entire ownership, it is like the, in the case of a wife and a husband, right? Very often you put the name of the wife just because it is a joint property. Then you have to actually prove that what was the source of the funds, whether it is not equally. Otherwise, it will deem to be 50-50%. Unless you prove that no, it is completely only the resident who has paid for the entire property.
Okay.
Depends on the source.
Yeah.
Source of investment.
In case of NRI is facing prosecution for non-filing of returns, compounding, whether it is advisable to go for compounding rather than the litigation?
Yeah, certainly. What was the non-resident? Does he have a TDS obligation or is
Yeah,
it
at that
significant?
time he had earned salary income.
That's it, but he did not offer that for tax.
Yeah, he migrated abroad and in kind of 3-4 years, he did not file the return.
But if he migrated abroad, then that salary was not taxable, no?
Immediately, like, he was R and OR, resident and not.
So,
not
so normally there is a concept that even when you go abroad and you are an employee of a foreign company, then India does not have a right to tax. Only the foreign company has a right to tax it.
So he was employed by Vodafone,
India or which UK?
the Indian
No,
Vodafone.
he may be with India, but then he must have been deputed to some other country, no? You said.
Yes, sir, America, and he was also earning
So that-
simultaneously rental income in India.
So that rental income will be taxable, but for salary income, it is possible to contend that he should have been taxed only in the USA, not in India.
So, but compounding is advisable than litigation.
No, so what I'm trying to tell you is that if you have a good case on the merits itself, then you can contest, don't go for compounding. But if say on rental income, it is a significant income, then go for compounding so that the litigation is taken care of. Depends on the merits of your case also, no compounding, or whether you will have a good chance.
Sir, I am an individual, so let's say, from April to June, I worked in India. Then I took the opportunity and went to US, wherein I have earned salary for 4 months. Then came back to India, worked in India. So while filing my return, this year, so since I worked in US, I got salary from there. So will that, and TDS or tax?
In most cases, you will be 183 days and more in India, no?
Yeah.
You will be a resident. Yes. Yes, yes.
If we read the DT between India and US, if we read that.
No. So as I mentioned, to say the same point, that you can be taxed in the USA provided you are a resident of the USA. In the treaty, the first thing they will have to decide is which residence test. Are you a resident of India or resident of USA? And if it is a tiebreaker, rule also is sometimes adopted. And then a final call is taken. In our case, it appears to be, clearly seems to be a resident of India,
Correct.
just gone for 4 months on deputation. So mostly you'll be an Indian resident.
So I have to offer that.
Yes.
And take tax rate. Yes. Yeah. Thank you.
So, one of the individual manages advertising campaign for a client in India. So for all Google Workspace and all e-marketing, advertising and everything. And he or she charges commission on basis of number of clicks and the managing and professional fees is levied on the invoice. So will equalization maybe attract or TPS provisions will attract?
Because there is the e-commerce operator is defined also to include online provision of services. Therefore, there could be, you will have to examine equalization levy. Is there a provision of service or is it pure commission? So,
provision of service actually.
so then there could be an equalization levy. One will have to examine it. I mean, prima facie, I can tell you the EL may apply, but since it is a pure commission, you can look at whether it falls under a treaty and there can be exemption. So the equalization levy will apply.
Okay, and so we have a Shutterstock kind of entity who makes so we can download images from there and we can edit those images. So actually, there is a restricted use. There is an end user agreement where it is mentioned that you cannot forward these images to someone, etc. So will TDS provisions attract in this case?
That is more than in the akin to the nature of royalty, because you are getting a right to use. You don't have a right to reproduce. The Shutterstock images, take those images and implement them in your whatever you want to do.
Yeah.
Like your emojis and all that, there could be other images like that. So that will be more in the nature of royalty.
So can't we say that it is in nature of copyright and it is not?
Yeah, so if it is a copyright, then it is royalty, no?
Yeah.
Because it is copyright, that's why it is royalty.
But there is a restricted use, so will TDS provision attract?
No, restricted use where I mentioned of software, it is because software was embedded in it and it is sold like a goods. Here there is no question of goods. You restrict that is a copyright is always restricted. If I give you lock, stock and barrel, is like the cases I mentioned where there is a sale of goods. So the whole point of restricted in a copyright, the person who has the intellectual property gives only a restricted use of copyright. So it will be taxable.
Then Shutterstock case only if I don't have any agreement with them and just download and use those images.
But it's basically implied contract.
Okay. So then also I have.
Whether you have an agreement or not is not really relevant. Yes.
Okay. And in case of non-resident payment, like you have said, we can calculate and apply the rate. So am I allowed or party has to go to ITO for?
No, so your chartered accountant should be allowed at the 15 CB also, or you go under 197 under the non-resident come, or you make an application under 195(2).
195(2) also we can make application. Okay.
But in many cases, as an officer, आपके पास अभी power है ना certificate करने का, हमारे पास क्यों आ रहे हो? So they'll set you back, and they may take a long time for it.
In capital gain also it is allowed. Like
yes, of course.
Okay.
Sir, if a lady has taken a loan.
So in many cases of payment to NR and capital gains, we always let the non-resident file. Because if he's going to invest in 54 EC, this, that, etc., I don't know. Let him get a certificate, I'll deduct tax on that basis. I don't know whether resident, non-resident, you will have to give me registration, documents, whatnot. And as he said, proof. So it becomes very complicated for the resident payer. Best for the non-resident payer to get a certificate from them.
If someone takes a loan and pays the interest for her personal use, and later on the person has left the country and still she is paying the interest, whether she would be liable to deduct TDS?
So the person had given loan, now he's become a non-resident.
Yeah.
And the loan is being continued.
He has not declared.
He has
not declared I am a resident because she is paying online, so she doesn't know whether the person concerned is a resident or not, and that person is not declared, she is still paying and not claiming anything, but then she is liable under TDS.
So now she will be liable if the person is a non-resident.
But she doesn't know.
How will the tax officer also know that?
She does not know about the residential status of.
Right. So basically then she can plead that I did not know, no, the person was always a resident. But that under FEMA, that fellow also has an obligation. He cannot continue a loan.
Under the bank also, if
Yeah.
a person.
It will be a FEMA violation.
If he wants if a non-resident wants to open the resident account, he has to be present in India.
Correct.
So he is not able to, he has not come after he has left. So how he will be able to open the account? The person in the.
He
bank
can open.
says, he can open from there. They will know while first application has to be signed and in India.
So this you're talking about practical case,
Yeah.
practical difficulty. So the resident can plead that I am not aware there is not all the address, except there are some case laws. Bangalore tribunal that if the resident address is all resident in India, etc.
But now
Then no need
they
it.
the resident because we are paying online.
Okay, online, yeah, yeah.
So very
No, no.
cautious.
That in the whatever deed or whatever they had entered into, they had entered into an agreement. That it mentioned that ABC resident of so and so JB Nagar, that means he's an Indian resident like that.
Social security.
A person becomes a resident by virtue of his stay by last 4 years, but he still continues to maintain NRI because the foreign national, he is not staying in India for longer time. Suppose under FEMA is non-resident, but after giving up, he becomes resident. So whether that NRI exempted still become taxable?
Strictly, it will become taxable, but
Seems painful to say any Indian resident, doesn't talk about residents. He is an Indian resident.
I think in non-resident, you have to look at only the Income Tax Act. No, you don't have to look at FEMA there.
But
And the exemption is given to a non-resident as per income tax.
exemption is given to an individual, that doesn't say resident or non-resident.
Yeah, yeah.
So to this, anyone who is
An individual who is a non-resident.
no, the section doesn't
I
mention
think
that.
it is. I think it will be time just to announce. Again, we'll examine.
Sir,
So
Indian company has imported the planting machinery, and at a subsequent step, engineers have come to install that machinery and for training. So whether fee paid to
that is
the
typically the fee for technical services. FTS.
or it will go with the plant and machinery. So
No. So if it is required as a part of the installation of plant and machinery, it was intricately connected. Then you can argue that it is a part of the cost of the plant and machinery. Otherwise, this is a clear case of FTS, fee for technical service.
Sir,
if training is also involved, then it will touch that fee.
Yes.
So Indian company conducted a seminar in Dubai and they have taken the services of Australian consultant. Then what about the?
It will be taxable if it is paid by an Indian and if it is,
But he's conducted in Dubai. He is.
as I said, no, 916, 917, not relevant where the non-resident is or resides. Or where the service is performed.
Yeah.
Section 916 and 917 is deemed accrual. It doesn't care where the non-resident resides or where it lives or where it.
Non-resident Australian, but services provided in Dubai.
So it is not immaterial. जब तक आपने इंडियन बिजनेस में वो पैसा डिबिट करना चाहते हैं ना, फिर TDS लगेगा.
इसमें तो अर्न कमा किया ना लेकिन.
तो इसलिए तो डीमिंग होता है ना. सेक्शन 916 और 7 में डीमिंग होता है इंडिया में. फी फॉर टेक्निकल सर्विस होगा आपका. अनलेस वो सर्विस किसका टाइप का है, अगर वो टाइप का है कि अगर ट्रीटी के हिसाब से आप बोलोगे ये फी फॉर टेक्निकल सर्विस नहीं है तो नॉट टैक्सेबल.
What about reimbursement of expenses?
एलोकेशन एज आई सेड अगेन, इफ इट इज इनकम अर्न्ड और आपने उसको एलोकेट कर दिया कि ये रीइंबर्समेंट है.
Software expenses like Microsoft, they have purchased 100 quantity in US and they are allocated 10 to.
So there is a possibility of saying it can be exempted. There is a Supreme Court decision in the case of Maersk India. अब देख लेना Maersk India करके decision है, उसमें लिखा है कि for those common allocation of जैसे MNC charges होता है, group companies को various charges करता है तो वो that is exempted.
Thank you, sir, for this very detailed presentation on NRI taxation. Before we proceed to the formal vote of thanks, at the last meeting when we had the budget screening, we had kept this quiz where we had to say that what would be the Nifty at the closing of the budget, the day end Nifty figure. So 3 participants have guessed correctly, 21,700. C. Kavita Pandey, C. Tejas Shah, and C. Hemant Gandhi ji. All those who are present here, I please request you to come forward and take your prize for the same. None of them. Kavita is here. She gets the clothing material. Thank you. As part of our Silver Jubilee Year celebration, we also have lucky draw for all our participants. We have 3 winners with us. I request to please take out 3 chits and we can distribute the prizes.
Yeah.